Yeah.
All right, we're going to get started. I think we're hoping there's a class letting out pretty soon. Hopefully we have a few more students joining us, but we're going to get started anyway right now. Good morning. My name is Bill McGrath. I'm an adjunct faculty member here and a member of the Board of Advisors for the IP Center. And I'm standing in this morning for Professor Lim, who's out of town, unfortunately, so he can't be here. He's director of the IP Center. So I just wanted to welcome you all and have a few announcements for you. And the first one concerns CLE, and apparently they're trying to lay down the law here. So if you're wanting CLE, make sure that you not only sign in, but sign out, because there's some new rules that if there's no sign out in time, you're not going to get your CLE. So make sure you sign in and sign out. And then I just want to mention a couple of upcoming programs. First is on October 15th. There's an IP lecture by Theodore Essex, who is a former International Trade Commission judge, and he'll be talking about the ITC from an insider's view. Then in November, on November 1st, is our big annual IP conference. So that's a big to-do, and it's a great event, a great conference. If you haven't been to it in the past, I highly recommend that you look into it. And then the following Monday and Tuesday, November 5th and 6th, will be an International IP Practice Seminar covering patents, trademarks, and designs. That's co-organized by Kunin and Bacher, which is a German law firm, and the World Intellectual Property Organization. So that's also a great program if you're into international practice. All right, and then, of course, we're delighted to have Professor Roberta Kwall here today to talk to us about moral rights. And to introduce her, I'm going to call up Emily Mosnick, who is the IP Law Society Vice President.
Thank you so much. Good morning. My name is Emily Mosnick, and I am the Vice President of the IP Law Society here at John Marshall. The IP Law Society is a student-run organization dedicated to fostering interest in and a lively discussion about the practice of IP law. To that end, the IPLS sponsors various events throughout the school year highlighting opportunities and current developments in intellectual property law. The IPLS also strives to leverage the law school's prime location by inviting local practitioners to interface with students and share their experiences practicing IP law in one of the country's largest and most active legal markets. I'm happy to introduce our speaker today, Professor Roberta Kwall. Professor Kwall is the Raymond P. Nero Professor at DePaul University College of Law. Professor Kwall received her undergraduate degree in religious studies from Brown University and earned her JD from the University of Pennsylvania. She also has a master's degree from the Spertus Institute for Jewish Learning and Leadership in Chicago. Professor Kwall has an impressive list of accomplishments to her name. She is an internationally renowned scholar and lecturer. She has published over 30 articles covering a myriad of subjects, from Jewish law and culture to authorship rights and intellectual property. Professor Kwall authored several nationally used law casebooks and 2 monographs. She writes extensively through op-eds, articles, and book reviews on topics relevant to the Jewish community, which have been featured by numerous prestigious publications, both here in the United States and abroad. Professor Kwall has 2 more books scheduled for future release. She is authoring Remixed Judaism, Preserving Tradition in a Diverse World, and co-editing the Oxford Handbook of Jewish Law. Professor Kwall has received numerous awards for her teaching and scholarship achievements. In 2006, Professor Kwall was designated as one of the 10 best law professors in Illinois by Chicago Lawyer magazine. She founded DePaul Law School's renowned Center for Intellectual Property Law and Information Technology, and co-directed DePaul's Center for Jewish Law and Judaic Studies for several years. In her esteemed position at DePaul, Professor Kwall teaches courses in property, intellectual property, family law, and occasionally Jewish law. She has lectured at law schools, synagogues, and other venues across the country and in Israel. Professor Kwall also taught at Tulane Law School and currently teaches a course on Jewish law and the American Jewish movements at the Radziner Law School in Israel. Writing under the name Professor Roberta Rosenthal Kwall, she illustrates the beauty of the Jewish tradition through her Facebook blog, and she is here today to share her devotion to this tradition with us. Please help me in welcoming Professor Roberta Rosenthal Kwall to the UIC John Marshall Law School.
Hi, everybody. Can you hear me? Yes, damn great. Emily, thank you for that lovely introduction. Bill, always a pleasure to see you again. So, and thank you all for coming. I hope we're going to have a fun time thinking about some things that maybe are not at the forefront of what we think about when we think about intellectual property. Sculptor Frederick Hart created the renowned work Ex Nihilo, which for many years was part of showcased in the Washington National Cathedral. The sculpture depicts the creation of mankind out of the torrential void. And in the film, The Devil's Advocate, Warner Brothers created a near exact reproduction of this work. And toward the end of the movie, how many of you have seen this movie, The Devil's Advocate? Okay, a few of you. So you might remember at the end of the movie, the figures on the sculpture become alive and they start to grope one another as the leading character, played by Al Pacino, I believe, encourages children to have incest. Interestingly enough, I'm teaching incest today in family law right after this lecture. All right. Hart was extremely dismayed. During the 13 years that it took him to create Ex Nihilo, he actually became religious and converted to Roman Catholicism. So he was not pleased by the creation of a near-exact reproduction and the use of this near-exact reproduction as the backdrop for a scene about incest. Ultimately, Hart received a settlement from Warner Brothers that required changes in the portions of the film to eliminate any perceived confusion going forward. But his agony over this situation was tellingly revealed in one of his narratives when he wrote, and I quote, "I feel absolutely outraged that a work that was meant to express the great majesty and beauty and mystery of God's creation has been radically perverted." So the act of authorship, of creativity, no matter what the topic of creativity, be it art or music or literature or whatever it may be, infuses the creator's mind, heart, and soul in the work itself. This relationship between the creator and the creator's works, if you will, is unique among really all other kinds of human production, given that this act of creativity can be so highly personal to the creator or creators. This relationship between the creator and her work that is protecting the personal interests in the creator's interests in the work is known as moral rights. That is the legal doctrine that protects these interests. What are these interests? We'll explore that in more detail in a bit, but in general, moral rights protects the creator's personal interest in her work, the right to claim attribution of a work, as well as the right to prevent any changes to the work that change the meaning or message of the creator's work. This conduct, when a creator's work is changed or attribution is violated, that conduct could be understood and should be understood as a form of stealing the author's work. And of course, the same can be said for violating the copyright interests in a work, and that's an area of law, copyright law, that, as we all know, is becoming increasingly popular, relied upon, and really probably, if not one of the most important areas of law, it's certainly at the very top. But copyright law really differs from moral rights in that copyright law protects the creator's economic interests in her work. The right to reproduce, the right to display and perform publicly, the right to distribute, and the right to make new works based on the original. Those are economic rights. They protect economic interests. Moral rights are different because, as I mentioned a moment or two ago, moral rights protect the creator's personal interest in her work, to safeguard attribution, and to safeguard the creator's subjective vision of that work. The author's meaning, which moral rights tries to safeguard, really personifies what the work stands for in the author's subjective judgment. And the author's message is really what the author hopes to represent externally. So meaning I think of as more, the author's meaning I think of as a more an internal concept, internal to the author, whereas message is external. Both are protected by moral rights. A strong argument can be made, and we'll get to this, that the violation of an author's copyright or moral rights interest can be considered within the scope of the Eighth Commandment, thou shalt not steal, and therefore within the scope of what that commandment is designed to address. Actually, when it comes to copyright as theft, I'm not going to deal with that because that's been dealt with very well by other scholars, most notably Professor Neil Natanel at UCLA Law School, who wrote a book that was published about 4 or 5 years ago called From Maimonides to Microsoft, which was about copyright as stealing. So I'm going to focus today on stealing in the context of moral rights with the author's personal attribution. Also, moral rights is far less known than copyright. And why is that? Well, that's because the law, the secular law here in the United States, is very cabined and very narrow when it comes to moral rights, as we will see. So whereas copyright, pretty much everybody's familiar with copyright, on the other hand, very few people, except for specialists, are familiar with moral rights because they're really not all that significantly protected. We will also talk about, after we talk about what the secular law, the United States law of moral rights look like, we will talk about what the Jewish law roots are of the Eighth Commandment, and I think there'll be some surprising revelations. I love that commandment revelation goes together. There'll be some surprising revelations, I think, for you when we get to that point. All right, so how are moral rights protected in U.S. law? Moral rights are contained in a little subsection of the copyright statute known as the Visual Artists' Rights Act. The Visual Artists' Rights Act was not part of the original 1909 Copyright Act. It was not part of the original 1976 Copyright Act. The Visual Artists' Rights Act was not enacted until 1990, which was 2 years after the United States had joined the Berne Convention for the protection of literary and artistic works. Article 6 bis of the Berne Convention recognizes the moral rights of attribution and integrity. When the United States had joined the Berne Convention, the entertainment and publishing industries vehemently opposed the enactment of more rigorous moral rights protection as part of our adherence to the Berne Convention. Congress eventually passed Vera in a narrative that I'll recount in just a moment that I think helps to understand why the law of Vera is peculiar in many ways, and in many ways not as well thought out as it needed to be. So how did Vera get passed? On the last day of the 101st Congress, it's probably 1989, Congress passed a major bill that authorized 85 new federal judgeships. Vera, the Visual Artists' Rights Act, was sort of stuck on to this federal judgeships bill. You might be wondering, what does Vera have to do with federal judgeships? And the answer is none. Okay, so how did this happen? Sponsors of the federal judgeships bill had to include several unrelated measures, such as Vera, in order to get the judgeships bill passed. So one of these measures, as I said, was Vera. Vera had already been passed by the House of Representatives, but it had been blocked in the Senate by several Republican senators. So, in the political genius that took place then and is still probably taking place, Vera was lobbed onto the federal judgeships bill so it would get the vote of those Republican senators who wanted the judgeships bill but did not want Vera. And that's how it happened. There was basically very little debate or discussion of Vera. I do remember, and this was a really long time ago, but I had been writing a lot about moral rights back then. I do remember being asked to give some testimony about the takings aspect of Vera, which we'll talk about in a little bit, and I remember giving some written testimony. But by and large, there wasn't a lot of conversation about Vera. It just was stuck onto the federal judgeships bill and just basically passed. The crafting of the bill was, and I'm going to suggest to you, remains problematic. So let's talk about, first of all, what types of works are covered under the Visual Artists' Rights Act. Well, by the way, as the name of the act suggests, Visual Artists' Rights Act, it defines art in a narrow way, meaning visual art. So if you're talking about music, or you're talking about literature, or you're talking about any other type of creation other than visual art, you have no moral rights in the United States. Unlike, by the way, the laws of virtually every other country you can think of, including third world nations, which is interesting. All right, but not all visual art is protected under Vera. Vera applies only to a very narrow category of visual art, such as paintings, drawings, sculptures. Photography presents an interesting scenario under Vera. Photography is protected, but only photography that's created for exhibition purposes only. If it's not created for exhibition purposes, photography doesn't come within the scope of the statute. So there was an interesting case in 2005 that actually tested the boundaries of Vera, and we learned from the case the boundaries are pretty narrow. In this case, there was a collaboration between a photographer, whose name was Lily, with his girlfriend, whose name was Stout. And what happened here is that Lily's photographs were incorporated into a piece of art that Stout was creating. It's like a coffee table type book, if you will. And she didn't give him attribution. So he sued her for violating Vera after, of course, they broke up. So the question was his work, his photographs, for exhibition purposes only? She argued, no, he took these photographs to help me out with my art project. And the court accepted that, and therefore he was denied the moral rights of attribution as his works not coming within the scope of Vera. Vera also excludes protection for what was going on in the devil's advocate that I talked about earlier. Specifically, reproductions are not covered, nor are objectionable contextual positioning of art, meaning when a work of Vera that is otherwise covered is used without permission in a way or in a context that the artist would object to. And again, that's what was going on in The Devil's Advocate, although it was a reproduction, not the original. But you can imagine situations in which the original is so being used. That is also not covered under Vera. Also not covered under Vera are works for hire. If a work is created for hire, and that's a work that is created by an employee within the scope of his or her employment, that work is excluded. Okay, now it's true that works for hire, the copyright vests in the employer. Okay, that's true. But why should that mean that the author, the creator of the work, loses her moral rights? I don't think it should mean that. A couple of years ago, the Copyright Office decided to take testimony and to kind of look at Vera. And I thought, wow, finally, this is terrific. So I wrote out 3 pages of commentary and submitted them to the Copyright Office, giving my perspective on Vera. By the way, I've written, I have a book out, one of those 2 monographs is called The Soul of Creativity, Forging a Moral Rights Law in the United States. I had done a very, very deep dive into Vera in that book and made a lot of suggestions about what needed to be changed. So I sent off a report that incorporated several of the suggestions that I thought were most important. When it came to broadening out the scope of Vera, the Copyright Office declined to act or to recommend any changes in that regard. The Copyright Office kept both the limited scope of Vera as well as the work for hire exclusion. By kept, I mean decided not to recommend changes. It would be up to the legislature, of course, to change it. And the report justified its position on a couple of things. The role of private ordering, for example, and the relative success of patchwork protections. I would dispute they're all that successful, the patchwork protections that have been used to actually protect moral rights. And there was also testimony that the Copyright Office relied on both in enacting Vera as well as in the report by another IP professor who was arguing that when it comes to visual art, singular works or works in a very limited edition are the most deserving of protection. I took that argument on in The Soul of Creativity, and I strongly disagree with it. However, when the Copyright Office report came out just last spring on the issue of Vera's scope, it did not recommend any changes at all, which was disappointing to me. Let's talk a little bit now about what rights Vera covers. We know now what kind of artwork it covers and doesn't cover, but let's talk about what rights Vera covers. So first and foremost, Vera provides an attribution right. It provides that attribution violations allow authors, covered authors, to the right to claim authorship of a work and the right to prevent the use of their names on works they have not created. And note that by that second sub-right, the right to prevent the use of an author's name on something he didn't create, note that that gives protection to people who aren't even authors, actually. All right, and it also, again, protects against false attribution. So that's one of Vera's rights. The second right that Vera provides is a right of attribution, a combination of attribution and integrity protection. This allows people to prevent the use of their names as authors when a work is modified or distorted in a way that would significantly prejudice the honor or reputation of the author. And thirdly, Vera provides just an integrity violation protection by preventing intentional distortion, modification, etc. Of a work that, again, is prejudicial to the author's reputation, honor and reputation. And along with this, Vera protects against destruction of works of recognized stature. I would note parenthetically that Vera's protection against destruction is actually unusual. Most countries do not protect against destruction on the theory that once a work is destroyed, it no longer reflects badly upon the author. But the United States has a different take for those works of recognized stature. There are several issues that arise by virtue of how these rights are framed and categorized. So let me share some of the problems with these issues. First of all, number one, we know that the right of integrity requires an intentional violation, distortion, or modification. But why should intent, the motives of the user, matter? Moral rights is not about the motives of the user. Moral rights is about protecting the dignity and artistic spirit of the creator. So intentionality has nothing, theoretically, to do with it. And so why should that be a part of the requirements under Vera that an author must prove in order to get protection? That makes no sense whatsoever. Similarly, why should the integrity violations have to be shown to prejudice the author's honor and reputation? Again, it's not, Vera and moral rights is not about public perception. It's about the dignity to the author herself in having her work be modified or distorted without her permission. So that's another problem with respect to that. Another problem is, what does it even mean to prejudice someone's honor and reputation? Vera provides very little guidance with that, and nor does it provide any guidance with respect to what it means to be a work of recognized stature. Now, with respect to the last point, what it means to be a work of recognized stature, here the 2019 report that the Copyright Office issued on Vera did recommend some changes. Notably, the report concluded that this requirement of recognized stature should require courts to conduct a broader range of inquiry in determining recognized stature than is currently the case. Currently, the recognized stature determination is usually made based on the views and opinions of the experts, the academicians. And the report, relying on a 2018 federal New York decision of Cohen versus G&M Realty, known more colloquially as the 5 Points case, which involved graffiti actually, determined that the graffiti there was a work of recognized stature, was within the scope of Vera, and more significantly, that a broader range of opinions need to be involved in the discourse in determining what is recognized stature. So the report suggested the following language for recognized stature, which is based on the California Art Preservation Act. So I'll just read this to you so you can get a sense for what the report recommended. Again, these are recommendations. It's still up to Congress to make a change. Seems like Congress is going to be busy for quite some time in the future, so I don't think moral rights will be at the top of their agenda, but you never know. Okay, here's the language. In determining whether a work of visual art is of recognized stature, the trier of fact shall rely on the opinions of artists, okay, art dealers, collectors of fine art, curators of art, museums, and other persons involved with the creation and marketing of art. Okay, those are the experts, and here's the significant part, as well as the opinion of the relevant community. Okay. What is absent from Vera, and frankly absent from the report in its recommendation for changes? Protection against contextual damage, as we've discussed before, what was going on in the Devil's Advocate. That is a very, very significant problem, because a lot of times moral rights violations don't necessarily result from actual touching of the work or changing of the work, but more in the context in which the work is being displayed. And there are many cases on that type of issue from other jurisdictions, or even cases involving, like 43A, the unfair competition provision of the Lanham Act, which has also touched upon some of these. One other point related to this that is a good thing, I suppose, from the report, the 2019 report. The Copyright Office did recommend that Congress take up the issue of enacting a federal right of publicity. And I have to say, in so doing, actually relied on an argument that I had made in this regard in my book, The Soul of Creativity. So what's the connection? The right of publicity is a legal doctrine that safeguards an individual's persona name, likeness, etc., against the unauthorized commercial appropriation of their persona. So you can't take somebody's name and likeness, put it in a commercial context, and without their permission. Many right of publicity cases do involve economic damage. The plaintiff is complaining about damage to her pocketbook, okay, as a result of the publicity violation. But there's a number of publicity violations that actually involve something more. They involve something that is more akin to moral rights. Okay, so one example of this involves the singer Tom Waits, who has a voice that's very distinctive. It's like nails scratching a chalkboard. And he's kind of a prima donna, he's an artiste, and he never allowed his voice to be used in a commercial context for commercials. And so Frito-Lay hired a sound-alike and used a sound-alike voice of Tom Waits to sell chips. And of course he wasn't happy. He sued, and he was really not complaining so much about damage to his pocketbook, he was really complaining about damage to his persona. And oftentimes, moral rights violations overlap with this to the extent an artist is complaining about the damage to her reputation by virtue of how something is being modified without her permission. So the Copyright Office does recommend that that Congress take a deep dive into the feasibility of perhaps enacting a federal moral rights law. This would not be a widespread help for moral rights, a federal right publicity law. This would not be so much of a change when it comes to moral rights laws, because again, moral rights are about the artist's personal interests. Right of publicity is about the use of a persona, but because some persona cases involve personal interests, that's sometimes where the art and the persona merge to some degree. It could be of some help if there was a federal statute that would be crafted to explicitly protect these kinds of interests. Duration. How long do moral rights last after Vera? This is another very problematic aspect of the Visual Artists' Rights Act, for reasons that nobody seems to understand, and there's really there's no evidence to even understand why this decision was made. There's no reports. Vera has a bifurcated timeline for protection. So for works that are created after Vera's enactment, Vera protects copyrighted works are protected just for the life of the author. By the way, it strikes me that I should have made one thing explicit up until this point, in that in order to be covered by Vera, you need to be covered under copyright law. Because again, Vera is part of the copyright law. So you're not going to have Vera protection if the work isn't copyrighted. That was an issue, by the way, in a case right here in Chicago that came out of the Seventh Circuit that had to do with the Millennial Park sculptures. Chad would tell me that was the sculptures that were there in the city. We did them down and destroyed them, and the question was, are these outdoor sculptures? Is that considered within the scope of the Copyright Act? So that has been litigated here. Anyway, so back to duration for a moment. Again, if the work is created after Vera was enacted, that's 1990, then the protection only lasts for the life of the author. And by the way, copyright law lasts for the life of the author plus 70 years in its most general sense. So what if a work was created prior to Vera? Well, if the work was created prior to Vera, but the work wasn't transferred by the creator, then, so the creator kept the visual art, in other words, to him or herself, then Vera protection lasts as long as copyright law lasts. Okay. So that's really strange. You've got two completely inconsistent time frames for protection depending on when the work was created. This was, by the way, sort of the topic that I gave testimony on for Vera back in 1989 or 1990. And the issue with the idea that if the work was created prior to Vera and the author has sold the work, okay, that would theoretically perhaps raise a takings claim. If you sell the work and there's no limitations on moral rights at the time of the sale, to enact that retroactively could be seen as a taking. Okay, so That's why the statute says if it's created prior to Vera, but the author hasn't transferred title, the protection can last for as long as copyright law. But that doesn't explain why anything created after Vera only gets protection for the life of the author. It makes no sense. So the Copyright Office did recommend a uniform standard, so that would be a good thing. What about waiver? All right, so Vera, according to Vera, an author can waive her moral rights if the author expressly agrees in writing to waive an assigned written instrument. Waiver means you're not exercising your rights, but you're not necessarily allowing someone to exercise them either. So there's a difference between a transfer and a waiver of rights. The statute also says, in one of the most criticized aspects of Vera, including myself, that one joint author can waive the moral rights of other joint authors. Again, makes no sense. Vera is designed to protect the personal interests of an author. The fact that two people are joint authors, they still have distinct personal interests in the work, and therefore allowing one joint author to waive her fellow joint author's rights, again, makes absolutely no sense. And fortunately, the 2019 report did recommend changing the ability, eliminating the ability of one joint author to waive the moral rights of another joint author. So in addition to all of these numerous flaws with Vera, and there are others, well, here's another one, fair use. Vera provides that, that Vera is subject to the fair use doctrine. It doesn't make sense either. Why? Fair use is about under what circumstances an uncompensated use by someone other than the copyright owner is or should be allowable. It's about money. Moral rights is not about money. And there could be instances in which violations of an author's attribution or textual integrity also could be fair uses. That could be the case, okay? But they're not one and the same. And so to have a blanket statement that moral rights are subject to fair use, and if it's fair use, you don't get to exercise your moral rights, once again, makes no sense. No recommendations were changed with that, with respect to that. Another area that is problematic under Vera, but there was not really much said about it, other than to note it's problematic, is preemption. Okay, so there are several states that have their own Visual Artists' Rights Act. The question has come up as to what extent are these state statutes preempted by the federal Visual Artists' Rights Act. It's interesting to note that it's not uncommon for various state statutes to differ from Vera. Some of them protect broader subject matter, for example. Sometimes the rights protected are a little bit different. They're not necessarily one and the same. And so the question is raised as to, well, how do you then make a distinction between what should be allowed to be protected under the state law versus the federal law? Keeping in mind that copyright is an area that is regulated really by federal law at this point. We don't have a state law of common law copyright anymore. And so does it make sense to allow states to even have their own Visual Artists' Rights Act? What if a state protected against objectionable contextual damage, which I mentioned before? Would that be allowed? Should that be allowed? The Vera provision basically provides that state laws are not preempted if they stem from activities violating rights that are not equivalent to rights under Vera. But what does it mean to be non-equivalent? And that topic, which also appears in the regular preemption provision of the copyright statute, section 301, again, outside of Vera, but preemption of other state laws impairing perhaps copyright law. It's a mess, it's a quagmire. How do you determine equivalency? There's just so much case law on that, and it's all confusing. One district court has actually said that the New York Moral Rights Act, the Visual Artists' Rights Act, actually has been preempted. Okay, so now you have a working familiarity with the Visual Artists' Rights Act, what it does do, what it doesn't do. limited forms of protection. So now let's get back to the topic of why violating an author's moral rights can and should be considered within the scope of the Eighth Commandment, thou shalt not steal. So, in order to really begin to address this issue, we have to begin our understanding of human creativity and the theory surrounding human creativity by going back to the creation narratives in the Torah, okay, the Bible, the Old Testament, however you refer to it. And you have to go back to those creation narratives there, in which God creates the world, and in which God creates, mankind, Adam and Eve. Interestingly, there are really two creation narratives. Okay, by that I mean there's one section that comes first, and then there's a break around chapter 3, and then there's another section, and there are two different narratives of how the world is created. Okay, from a theological standpoint. But both of these narratives taken together are really the most celebrated stories of human creativity in Western society. So that's pretty significant. In fact, when Frederick Hart was first commissioned to create Ex Nihilo, and he wasn't religious then, he converted during the 13 years that he created the sculpture, but the first thing he did was consult these biblical narratives of creation, of divine creation for human creativity. Okay, so chapter 1, verse 27 of Genesis provides, God created man in his image. Probably most of you are probably familiar with that language. Historian and former librarian of Congress, Daniel Borston, wrote that language furnishes a path leading man to regard himself as a potential creator, and thus underscoring a parallel between divine and human creativity. I read Daniel Borston's book, The Creators, around 2004. I took one summer where I wasn't going to write anything. I was just going to read. And I spent most of my summer reading his book, which is well over 1,000 pages and not an easy read. But when I read that sentence, a light bulb went off. And I thought to myself, wow, I've read those narratives so many times, but I never made that, and I'd written about moral rights for a good long time by that point, right? And I never put the two together. And I thought to myself, wow, how interesting is that? I wonder what the Jewish perspective on human creativity would be. Because I realized that if I could figure out what Judaism said about human creativity, that would give me a good basis for arguing the theory of secular law and how secular law here in the United States might be modified or shaped in order to better protect authors' spiritual interests. So I then set about a research agenda that led not only to looking at the Jewish perspective on human creativity, which is very rich and very full, and frankly very complicated, because whenever you're working in Jewish law, you need to have a lot of knowledge, which is why I went back and got a master's degree. And then I went into Christianity, because one of my colleagues said, well, that's fine that you're doing this, but the United States is basically a Christian cultural state, and so you need to understand what the Christian theory is of human creativity. And I said, good point. Okay, so I'll go research that now. I found a wonderful book by Madeleine L'Engle, Walking on Water, and where she explores the basis for human faith in the Christian tradition. And I learned that the Christian tradition, not really surprisingly, is very similar to the Jewish traditions. So I thought, this is great. We need to better understand what motivates human creativity from a spiritual, inspirational, internal perspective. And if we could put that out there, then maybe we can get Congress to listen to these ignored theoretical interests in the law and maybe tweak our moral rights statute to better protect these internal spiritual interests that are largely unprotected, as we've just seen. So what does this theory of human creativity look like? And why is it important, and how does it relate to the Ten Commandments? Okay. So, the way that the rabbinic tradition works is you've got the Torah, okay, which is a conglomeration of narrative, of stories, of legal codes. It's a very broad-ranging book, which many of you probably know just from your familiarity with the Old Testament. And what the rabbinic tradition does, and when I say the rabbinic tradition, I'm talking really about the rabbis who basically shaped Jewish tradition in the early centuries of the Common Era. And what they did, what their process was, okay, is they really take a deep dive into the Torah to search for meaning in the text, and they come up with interpretations of the passages, as well as interpretations of the laws that allowed the Jewish legal system to carry forward. So unlike Christianity, Judaism as a religion is a religion of law. There's a lot of laws, there's a lot of ritual, it's all very legally based. And so the rabbinic scholars looked at these creation narratives in Genesis as challenging man to create and to transform and the wilderness into productive life. In fact, the rabbinic tradition believes that the most important commandment to humans is to create, to be a partner with God in making the world better. This is all part of the spiritual Jewish tradition on creativity. The word create in English actually is derived from the Latin verb creo, which means to give birth to. So Rabbi Karen Kadar, whose synagogue is up in Deerfield, in an essay that she wrote in a book of scholarship, she wrote that these opening verses of Genesis actually reveals a description of the womb. And she writes, "The deep, unformed darkness is the womb, ripe with potential. The water, the darkness, the water is the amniotic waters that protect the fragility of life." It's a wonderfully rich metaphor. You look at the creation of heaven and earth as basically being a description of the womb. The idea that an author gives birth to her creations, which is known, by the way, in the legal literature as the parental metaphor of authorship, provides the tremendously rich foundation of the connection that an author has with her works. An author as the parent of the work the author creates. Just like God, okay, according to the theology of the Old Testament, is considered the parent of humans. And by the way, this metaphor of parental authorship really defines how we define stealing, actual stealing, in connection with works of authorship. So as early as 1710, Daniel Defoe referred to literary theft as a type of child snatching. And the word plagiarism is derived from the Latin term for kidnapping. Now, there is a rich tradition that the Eighth Commandment applies to kidnapping. Okay, it's not just stealing objects. It also applies to stealing human beings. And what I'm suggesting is that it also applies to stealing the spiritual byproducts of an author's works of creativity. Okay, and that's my working thesis. Now, the Jewish roots for copyright law, okay, as well as moral rights, there's a lot of richness to the tradition. As I said, Neil Netanel has written a lot about about Jewish copyright law, and in the book that I mentioned. But again, we don't really know. Moral rights are much less. They're much more off the grid for most people. So it might surprise you to know that the first recorded documented violation of moral rights, according to the interpretation of the rabbinic Jewish tradition, occurs with respect to the story of Adam and Eve. Usually, some of you may know, Eve usually gets the bad rap in terms of the creation story, triggering the downfall of humanity, exile from Eden. I mean, nothing good came out of this, right? Here's what really happened. If you look at the Torah, if you open up and you look at the Bible and you look at the Torah, you see that in chapter 2, verse 17 of Genesis, God commands Adam not to eat from the tree of knowledge. That's what the English translation will say. But in chapter 3, verse 3, Eve tells the serpent that she may not eat of the fruit or touch the fruit, or she will die. So Eve's recitation to the serpent looks different because all of a sudden we have this new incorporation of touching, which isn't there in the earlier verse. It's not there in what God commanded Adam. So this is a little problem, right? And so the rabbis understood, again, the rabbis at the time of the Talmud, when the legal traditions and the narrative traditions were being developed, the rabbis knew that this was a problem. And the rabbis had an explanation for what happened here. So according to the rabbis' tradition, and again, the rabbinic tradition comes from, in part, the written Torah, okay, what's written in the Bible, but also accompanying oral traditions that were prevalent and in existence, and the rabbis knew those oral traditions and used them, as well as the written word. Okay. So according to the oral tradition that are used by these rabbinic Talmud sages to understand the biblical passages, the naughty serpent shoves Eve against the fruit and said to her, okay, you touched the fruit, you didn't die, you can eat the fruit. That's what happened. And she saw that she didn't die from her hand touching the fruit, and that the serpent was able to convince her that she could eat, and then she offered the fruit to Adam as well. Now the tradition explains how this happened. Adam wanted to add a safeguard in the instructions that God gave him when he spoke to Eve. So Adam added, don't touch. But he didn't tell Eve that that was his own addition. So in other words, he let Eve think that the original command from God was don't eat, don't touch. Originally, it was just don't eat. So what did Adam do? He violated God's moral rights by, first of all, not providing appropriate attribution to God's words. God never said don't touch. And that would be actionable under Vera if words were actionable, which they're not. Okay. And he modified God's words. This is the earliest recorded first moral rights violation. And look what happened. Humanity just never was the same afterwards, right? We're laughing, but to be honest with you, the shoe fits, right? The shoe fits. I mean, this is pretty significant. All right, so the moral lesson about not stealing an author's work by violating their attribution and integrity interests comes from Genesis, okay, and the interpretive rabbinic tradition. But virtually all works of Jewish law on this point to a different source. Now, again, remember, Jewish tradition involves the narratives, the culture, and it also involves the law. And so here, too, the rabbis, particularly starting in the Talmudic period, the early centuries of the Common Era, that's when they were really codifying Jewish law. Okay, it wasn't codified before that time, and interpreting and really trying to, in creating the system of Jewish law that is still very much followed by religious Jews today. I mean, it evolves, it changes, but the core of Jewish law really has remained the same, because Judaism is considered a religion that's countercultural and therefore really shouldn't be influenced by the external society, but really about what God's commands are to people. And that includes, by the way, the Ten Commandments. So the earliest source of Jewish law that deals with moral rights, although of course it's not called that, is from a statement in the tractate of Pirkei Avot, which means the ethics of the fathers. And this is in the Talmud. The Talmud, as some of you may know, is considered the central book of Jewish life and Jewish law. About 25% of the Talmud is narrative, so there's a lot of narrative and folklore and rabbinic wisdom, and there's a lot of interpretive law as well. But it's not a black and white code, usually, and neither is, and Pirkei Avot appears in the Talmud. This tractate dates back to between the years 200 and 500 CE, so it's very, very ancient. And in Pirkei Avot is the following: whoever repeats a thing in the name of one who says it brings redemption to the world. I'll just repeat that so you can think about it a little. Whoever repeats a thing in the name of the one who said it brings redemption to the world. And the commentary to this verse, the rabbinic commentary, emphasizes that one must display indebtedness to a source, mention him by name. Essentially, it prevents taking false credit for someone else's statement and implicitly embodies a responsibility to quote accurately. Good advice for first-year law students in their legal writing sections, right? I mean, this is still the basis of anti-plagiarism. So again, this appears in the Talmud, and the Talmud itself is a very, very interesting example of how attribution is handled in the context of collective authorship. So the Talmud often uses the phrase Rabbi X said, or Rabbi Y said, but when the Talmud does it, it doesn't really mean Rabbi X himself. In this case, it is himself, or Rabbi Y himself. There were no female rabbis at that point, right? So they were all male, and they were all he's. So what does it mean? It means Rabbi X and his disciples said. So the idea of attribution in the Talmud is different from the way we think of it, meaning that the only instance of a failure to attribute that is considered not okay in the Talmud is only if everyone wouldn't know otherwise who the author really is. All right. So to put it another way, according to Talmudic culture, everyone knew that the sayer was understood to be either Rabbi X or Rabbi X's disciples and later students, not necessarily just one person. And so the only time that failure to attribute was actionable is if people wouldn't know who the real sayer was or what the rabbinic school was. So the point is, when we're talking about collectivity, works of collective authorship, and the Talmud is that, because if you ever see a page of Talmud, you'll see various texts, and then all around it are commentary, okay, written by other authors, and even the text of the Talmud itself, it's not linear. It goes back and it goes forward because it's jumping between centuries. Like the Talmud doesn't start in, the beginning of the Common Era and go to like 500 when it's redacted. It's back and forth, back and forth. Studying Talmud is actually extremely hard. It's very, very difficult to do. And I'm certainly no expert at it, but it's extremely challenging. So I think the Talmud's collective culture, authorship culture, really foreshadows our current digital reality. As we know, just from our experience today, digitally created works present the greatest challenge when it comes to attribution and integrity violations, because things can be changed and attributed digitally so much more easily than they can be manually. And it creates a lot of difficulty to think about how should attribution work in the context of this type of collective authorship? How should integrity violations work? And again, I address some of those issues in the Soul of Creativity. The one thing that I guess I would like to close by saying is that given how complicated secular law has become, it's sort of interesting to see that the Jewish tradition actually has a way of sort of dealing with the culture of collective attribution and collective integrity dating back to the Talmud. So it'll be interesting to see if in the years going forward here, as we try to continue to work things out in the States, whether Jewish tradition will serve as a source of wisdom for all of us, given that some of these issues were addressed then. I'll just close by, I'm going to take questions, of course. I'll close by saying that if any of you, Emily referred to my Facebook page, which is under Professor Roberta Kwall, but I'm also on Twitter, and I'm pretty active on Twitter, and my handle is just Roberta Kwall. So with that,
Thank you, Bobby, for that wonderful, fascinating presentation of moral rights, and particularly the religious aspects that we don't tend to think about too much.
right.
Now, can we sit here to take questions?
Yes, would be preferred.
Okay. So, well, let's just open it up now for any questions that you have for Professor Kwall.
Questions questions, reactions, comments, doesn't have to be
Anything,
questions.
right?
Yeah.
I have one question. When you were talking about the duration of moral rights, and post Vera, it's life of the author. So it doesn't matter if they assign rights or anything else, or transfer them in any way?
Well, post-no transfer wouldn't matter post Vera, because the transfer issue was really, the concern there was for transfers that occurred before Vera, right? Because that would be a takings issue. But in terms of post Vera, where it's just limited to the life of the author, theoretically, you could sell your work of art, and authors do this all the time, your painting, but you would still theoretically retain your moral rights to that.
Even though you're no longer on the copyright?
Correct. Correct. Because remember, even with copyright law, your ownership of the work itself that you paint, let's say, is distinct from your ownership of the copyrights in it. And Vera works the same way.
One other question, and I think this may relate to the New York case with the graffiti, is moral rights when you've got the art on a building and somebody wants to tear down the building.
Yeah, so that's a complicated area under Vera. There's been a lot of law on. There has been, I think that's probably the most singly litigated issue under Vera is, what happens when the work becomes parts of the building. There's actually a particular provision of Vera 113 that governs that, but it's complicated. It's a little too complicated to go into here without having the statute in front of us. But it is an era. There's some provisions for balancing. What the law tries to do is balance the right of the building owner to do what he or she wants with the building and the artist. And so there's notice provisions trying to get permission for the building owner to do what he or she wants to do with it.
Has there been case law debating between moral rights and the Digital Millennium Copyright Act on false copyright management information?
Yeah, there is a provision of the DMCA that has been held to tap into moral rights. I didn't really talk about it because it's such a niche area. And that was actually embraced by the copyright report as being a good thing. But it's so narrowly applicable because there were so many cabining aspects of that DMCA provision that it doesn't come up that much. I don't think that's ever been litigated even.
What kind of awards are you seeing for moral rights besides having the devil's advocate have to change the work of art, which doesn't sound like it related to moral rights to Vera necessarily?
Well, it didn't. I mean, first of all, that case might have actually even predated Vera. But even if it hadn't, it wouldn't have been covered by Vera because it was A, reproduction, and B, it was a contextual, objectionable use, which is not covered by Vera. Vera is not highly litigated. It's not like there's a ton of litigation on Vera. I would say every year if you get one or two cases, that would be a lot. Oftentimes they get, dismissed at an earlier stage. I think the 5 Points case is probably one of the more recent ones that's talked about because of the change that the court made to interpreting works of recognized stature. So when you ask what kinds of awards, one case in which that actually bears on that point, this is a 1999 case, I believe, from Indianapolis, and it was called the Martin case. And what happened there is the city, I believe it was Indianapolis, destroyed the artist's work. And their defense was, well, we didn't know, like ignorance, basically. And the court accepted the city's ignorance so as to avoid giving the author, the artist, enhanced damages. Right? Now, again, this is an older case, 1999. There's still, the last survey that was done still shows, going back 5-6 years, widespread ignorance of Vera and particular provisions of Vera. So it's hard to really answer your question like what kinds of awards are you seeing because it doesn't get litigated a whole lot. And when it does get litigated, it's not clear that you have Vera violation, and that was part of the problem with the case here, the Chapman versus Kelly, which goes back maybe 10 years or so, that was litigated here in the Seventh Circuit, but the holding was it didn't the outdoor gardens, wildflower garden it was. Landscape art, it was landscape art that was an issue. It didn't qualify under Vera. So, I'm not sure the court was right about that, but that's something.
Let me follow up a little bit about this, because I think it's an interesting tension between one of the things you said as far as not about money, and I think that is true.
Yeah.
In a sense, that can create a problem with enforcement. Would you agree with that? Because if it's not about money, and you're an artist and you don't think you're going to recover anything, but there's been a violation, and you want to get a lawyer, you're either going to have to pay out of your pocket or hope that there is some kind of damage award. So it seems to me, unless there are some awards, and this may be why there's not that much litigation, because you have a problem recovering. There's not that many cases where there have been large awards. Now, the exception, the 5 points case, I think was a boon to potential VARA plaintiffs, because the court there awarded $6.75 million to the plaintiffs. Now, there were 49 different works involved,
Yeah.
but and there was horrendous willful infringement by the defendant, and just chutzpah, can I say that?
Yeah.
By him in terms of whitewashing everything before everything was really kind of settled out by the court and so forth. So the judge was outraged and awarded us very substantial statutory damages into the willfulness range. Because there are some good things about damages that pour over into VARA, which is statutory damages are available, even if there is no registration. With a copyright situation, you have to have a registration in place prior to infringement to be eligible for statutory damages, which are damages that you can award without reference to actual monetary damages. It's a range that a court can just in its discretion award, and that's how the 5 points case.
Yeah. I think that's probably right. I might suggest that I think the relative infrequency of awards in either litigation goes a little bit beyond that. Again, it applies to a narrow sector of works. In order to get a claim, you have to hire a lawyer. It's going to cost money. Most artists, unless they're really big names, don't have necessarily the money to do that. And so I think that there's a lot of reasons why we don't see a lot of litigations. And also it's just a very, the truth of the matter is, given American society, we are, you could say it's because of our capitalist tradition. You could say it's because we're not a culture like France that really, loves and appreciates the arts. I mean, there are all kinds of theories, but the point is that moral rights just hasn't gotten traction here. Unlike, again, virtually everywhere else. I mean, it really is so amazing, and not in a good way from my perspective, that we have been able to get by with such skimpy moral rights protections, and still getting by because the Copyright Office really, doesn't just recommend it to some very, very narrow tweaks to the statute, as opposed to broadening it up. Oh, you asked one, so I'm going to...
You talked about, in Vera, there's fair use provision that sort of doesn't really make a lot of sense with what the heart of moral rights is. How does fair use and moral rights get treated in other countries, or they just keep infringement issues away from moral rights, and it's just different?
Yeah, it's separate. I mean, it's a separate, moral rights are litigated in other countries, and again, there's a difference in the civil law tradition, which is much more hospitable to moral rights, because moral rights were essentially born, if you will, in Germany and France, where there was a greater appreciation for works of art. But the common law traditions, England, Australia, were a little slower to come to the party. But even those jurisdictions are much more extensive. So there's, I think, somewhat of a difference between the civil and common law traditions. But basically, yeah, moral rights is litigated, but it doesn't, it doesn't become convergent with copyright law. So you're going to litigate fair use based on the issue is this uncompensated use of fair use? Was it appropriate? It's a separate question from, was there damage to the author's dignity by virtue of an attribution or intended violation? So there are two separate issues. Oh, yes.
So I have a question on, you made a comment about, you can't assign or transfer your moral rights.
Well, you're allowed, no, I said you're allowed to waive.
Right. So when you're drafting agreements and I'm purchasing visual arts from somebody, do I put in those agreements a provision that author waives their moral rights?
All right, who are you representing, first of all?
The acquirer.
The acquirer. Well, remember that copyright is distinct. Copyright rights, okay, including fair
That I
rights.
understand.
Right.
Separateness of those.
They're completely distinct. So in order, that would have to be something that would be separately negotiated.
Right.
But I guess the question is, I'm not sure that the acquirer, right, that there would be a legal basis for the acquirer to be able to exercise the moral rights of the artist. Because remember what moral rights are. They are the personal interests in the artwork. From my point of view, moral rights should expire with the author, not be consistent with copyright law.
But if the author is selling it, wouldn't it
Well, he's selling the work,
right.
but not.
Would it not behoove me to get a provision in that agreement that requires the author to waive their moral rights?
Well, waiver is different from transfer, first of all.
I agree.
Right. So if the author were willing to comply, as of right now, if the author were willing to comply with the waiver provision in Vera, sure. If your client could get the artist to do that, there's no reason why that couldn't happen.
But is that something important to think about to just eliminate future disputes?
Well, I mean, I guess it's hard to kind of imagine. So would your client, ever be wanting to display the art or whatever in a way that would violate the attribution or integrity interests of the author? And if that were the case, then maybe it would be worthwhile to track the language of Vera and to draft a clause that would comport with what it requires. Absolutely. Absolutely. And the truth of the matter is that at least the evidence suggests that most artists aren't sufficiently. There's an interesting question as to whether most artists, particularly small artists, not well known, but just more everyday type artists, are sufficiently informed even to waive their rights. That's an issue in law generally. Is someone sufficiently informed to waive? The truth is, waiver of moral rights is not necessarily something most people know about. So I would say part of it depends on who the author is as well. Yeah.
Does the waiver have to be in writing? Because I can just see a situation where you have two or more artists working together. They kind of have a fall, like that boyfriend and girlfriend's like, I made this
There was
first.
no waiver. Yes, it does have to be. It's a specific requirement that it provides.
Just to add a point on the waiver, to your question, in particular, if you are representing a building owner, you want to have moral, whether it's in acquiring a sculpture that goes in the lobby or what's going on a lot now is mural painting on the exterior. And just as the artists don't always know these rights, the building owners even less know their rights. And so what a lot of the current litigation is over exterior wall murals. And then it's like the 5 points. The building owner wants to tear down the buildings, and it's a huge problem. So building owners need to be thinking along other area, I've never been totally clear on it. So, is the extent to which the question of display can affect the modification rights? Let's say the being, Anish Kapoor, and I assume the city owns it, I'm not sure, owns the sculpture. Let's say they do. It's been displayed all these years, but now, let's say we get a new mayor, somebody who's, whatever, and they decide to move it into a warehouse.
Yeah.
Not take it out of public display, a piece that was intended for public display.
Yeah.
And now it's in a warehouse, at Midway Airport or something. Would Kapoor have any viral rights that might come into play here?
Well, assuming, okay, that the work is covered by Vera, let's just make that
Right.
assumption. Okay, a sculpture could certainly be covered by Vera, so let's just make the assumption that it was created at the appropriate time and what have you. So it's not clear to me that Vera would cover that, because as you described that situation, my mind automatically goes to that's more analogous to a objectionable contextual display, right? There may be a contract
Or non-display.
or non-display. There may be a contract issue,
Yeah.
depending on what the contract said about the rights to display. Okay, but that's not what you're asking. You're asking about whether there was a violation under Vera. And so it's not a modification of the work, and it's not a failure to attribute the work. It's really what I see as that is a facet of contextual, objectionable contextual positioning. That's not covered under Vera. So again, that's a great example because that's part of the problem with the Visual Artists' Rights Act. It doesn't cover things that can easily surface and that ought to be covered.
So you're familiar probably with the Fearless Girl situation. You remember that? The Wall Street bull out on Wall Street,
Okay.
and an artist created Fearless Girl. This was in a lot of the newspapers. It never came to court, but I think letters were exchanged. I don't know how it ended up. The girl, a young, strong girl, was placed 15, 20 feet in front of the bull. Like, don't mess with me. Would that be a contextual case situation? If
On the part of the artist?
the artist of the Fearless Girl.
Of the artist of the Fearless Girl.
The bull, the artist who
okay.
created the bull is saying, hey, you've created a derivative work here, and you're also modifying my work by adding a new sculpture into it.
Well, so I mean, that gets a little tricky. The derivative work, that's a copyright issue, that's not there.
Right.
So the modification, I mean, from what you're describing, my question would be, well, you're not really modifying the work, the Fearless Bull. You're placing something next to the Fearless Bull. Again, there may be contractual limitations on that, okay? But short of contractual limitations on that, that's not a modification to the work itself. So again, that would fall back into objectionable contextual abuses, and again, that's not covered under there. Those are good hypos, though.
So following up on the bean example, the bean itself is positioned and to reflect skyline and buildings, taking it and putting it in a warehouse does provide a different context to the art aspect of
Sure.
that. So would that trigger it potentially?
But that's not covered. That's the whole problem. None of that is covered. Unless it's a modification to the work itself. Okay? It's not, there's no provision in Vera. Where you place the work is not part of modifying the work itself. Now, I suppose if one wanted to make a creative legal argument, they could say, well, there's a thin line between positioning the work and modifying the work. And I get that. Would that fly? That's a great question. I'm not sure. I honestly don't know. I think it depends on whether you had a court that was sympathetic to what Vera's trying to do, or a court that's not sympathetic.
It's definitely up in the air.
I think it's up in the air.
Yeah. Professor Kwall has to teach class in a short while, so we're going to let her go. But thank you.